And thank you, everyone. Thank you for your patience today. Had a couple committees in a row. We're ready to get started. Madam Clerk, if you go ahead and take the roll.
Representatives Bricken, Bolso, Capley, Eldridge, Gant, Garrett, Grills, Harris, Lamberth, Littleton, Parkinson, Powell, Russell, Stevens, Todd, Vice Chairman Jernigan, Chairman Farmer. Mr. Chairman, you have a quorum.
All right, members, we ready to get started? We have anybody like to have any recognitions or comments? Chair Lady Littleton, you're recognized.
Thank you, Mr. Chairman. Today I have Gracie Weekly from Cheatham County with us today. She's shadowing, so she has a good day to be here because we have a good crowd and lots of nice bills. So let's give her a round of applause.
Members, anyone else? We get started. Representative Parkinson.
Thank you, Mr. Chair. I know this doesn't have anything to do with this committee, but a few years ago, we declared April as Barber Health and Beauty Month. So, if you will, do something nice for your barbers and your beauticians and your stylists and anybody that's in the healthcare business. Would appreciate it.
Leader Lamberth, you're recognized, sir.
Thank you, Mr. Chairman. And we didn't have an opportunity because we're running out of time in that committee, but your subcommittee chairman gave us plaques and closed his committee just a little earlier this morning. And I wanted to give him public applause for the good job he's done. And Mr. Chairman, I know you'll brag on him in coming weeks, but he's done a fine job. Thank you, Chairman.
And thank you, Leader. Excuse me, Representative Eldridge, you're recognized.
Thank you, Mr. Chairman. I just wanted to recognize we have some folks in the back there is from Granger County and Morristown, and we welcome you all here.
All right, members, does anyone else have anyone they'd like to recognize or any comments they'd like to make before we get started on today's calendar? All right, seeing none, just a couple of housekeeping issues. Members and folks that are here and watching online. Item number 4. House Bill 1386 by Chairman Reagan he's asked for that to be taken off notice. Any objection? Seeing none. House Bill 1386 off notice. Also, members, moving down, item 12, House Bill 2644 by Representative Leatherwood. He's asked for that to be rolled 1 week. Any objection? Seeing none. Roll for 1 week. Moving down, item 19, House Bill 2508 by Representative Harris. He's asked for that to be rolled for 1 week. Any objection? Seeing none. 1 week. Moving on down to item 21, House Bill 1349 by myself, Chairman Farmer. I've asked for that to be taken off notice. Members, any objection for that? Seeing none. House Bill 1349 off notice. And also, members, item 22, House Bill 2001, that's also a bill that I'm carrying. I have a late filed amendment that probably needs to wait to be heard next week. We are going to meet next week. So, is there any objection for rolling that bill 1 week? Any objection? Seeing none. House Bill 2001, roll for 1 week. Okay. And I saw Chairman Faison sitting there, ready to present his item number 1, House Bill 2936. You've got a motion and a second, sir. I'm looking at 2 amendments. I believe 17296 is the last one that was filed. Is that
Thank you, Mr. Chair. That is the amendment that writes the bill.
Very good. You've got a motion and a second. Members, we go ahead and like to adopt that. Any objection in adopting House Amendment 17296 to House Bill 2936? Say aye. Aye. All right. You're back on the bill as amended, and you're properly recognized.
Thank you, Mr. Chair. Committee, so good to be with you. Mr. Chair, with your indulgence, I know that there are people on both sides of this bill. Would this be a good time, or do you want me to talk about the bill first, or let the people who are...
Representative Faison, why don't you go ahead and give us an explanation of the bill, and then we can take some questions that may help us out.
Committee, I'm so glad to be with y'all today. Throughout your life and mine, there are political winds that change. There are influences that come and go. There are beliefs that evolve and change based on what's in vogue at any given time. Societal norms actually change based on the culture where we are in the world. But regardless of all the winds and things that change, things that come in vogue, things go out of vogue, what we do know that has never changed, regardless of where you're at or where we find ourselves in history, is the absolute important role of a parent. I hope that we as a society, that we, us, and our society should hope that the importance of the family is the true nucleus of the development of a child. I've been working on this bill for a while, and I found a quote by Rajat Manachad, and this is what he said. It's beautiful. A parent's love is the foundation on which a child's world is built. Parents are the first teachers, shaping minds and hearts with love and wisdom. A mother's arms and a father's guidance are a child's refuge in life storms. A parent's love is whole, no matter how many times it's divided. With that, this bill, what I'm seeking to do is 4 basic and fundamental ideas. Parents have the right and sole responsibility of these 4 things. They have the right to develop the spiritual health of their child, if they are spiritual or if they're not. They have the right to be in the room and deciding what takes place with the mental health, what takes place with the physical health, and the choice of the education of a child. This bill, if y'all saw fit, would allow those 4 things to be enshrined into the law here in Tennessee. And that's basically what this bill does.
And thank you for that explanation, Chairman Faison. I have Representative Parkinson. You're recognized.
Thank you, Mr. Chairman, and thank you, Chairman Faison. The 4 tenets. Give me those 4 tenets one more time.
So the parents have the right and the final say for the spiritual health, the mental health, the physical health, and the education of a child.
Okay. And thank you. And I actually appreciate that. However, I gotta the mental health. If we know that a child is dealing with or facing those challenges or with their mental health, and let's say the parent, or even physical health, right? And let's say the parent denies that child the treatment for either mental health or physical health based on their beliefs. How does that work with, government agencies, let's say DCS or somebody else that would want to interject to make sure that that child receives the help that that child can receive?
Chairman Faison.
Thank you, Mr. Chair. Representative Parkinson, excellent question. So a few things to answer that with. First of all, this bill works in conjunction with the mature minor doctrine, which somewhat hinders on some of your question. Secondly, there are already court opinions and case law that have decided when a parent would keep treatment from a child that would be life-saving. This bill doesn't impact any of those court decisions.
Representative Parkinson.
Okay, so and my concern is we're enshrining in law the language, which would now change how the courts would have to decide that based on the language of the law. And maybe this is a question for legal, Mr. Chairman, if we enshrine this language or codify it in the code, would the courts then have to base their decisions on what we're putting in law? And I understand, Bill, because I want to be in control of my child's. Well, I can't now; they're grown, but I would have wanted that control, as a parent. But I'm also concerned about those parents that are so far, outside of what could possibly be the norms, or that their children will be affected.
Chairman Faison.
Thank you, Chairman Farmer. So one thing I will add, this bill does not preclude if you as a parent have been neglected or abusive. Obviously, we as a state believe if you have proven already to be a parent of neglect, a derelict parent, or an abusive parent, this would have no institution over you. This is only for parents who have presented to us as society and living a normal life and have proven that they are the best option for their child.
Mr. Chair,
Representative Parkinson, do you have any follow-up?
I just want to ask legal something real quick, if we can. Can we
All
go
right,
out-
that's
can we go
fine.
out session?
Any objection? Members seeing none. Ms. Ansonia? Well,
Oh.
question first. I'm
Okay.
sorry,
Oh,
Representative
okay.
Parkinson.
Thank-
I should start with you.
Yes, sir. Yeah, thank you. So based on the language of the legislation, are we creating cover for those parents that decide that their children will not receive the care based on their beliefs or their ideology if a child needs mental health care or even physical care?
Ms. Ansonia, you're recognized.
The health, Elizabeth and Sonia Legal Services, the healthcare portion of the bill is found in section 2 and in section 63(1)(173)B of section 2. It states that except as otherwise provided by statutory law, case law, or court order, and then it goes on to provide what is prohibited. So anytime that there's a conflict between this statute and another statutory law, case law, or court order, that should prevail based on that language.
Any follow-up, Representative Parkinson?
Yes, sir. Thank you. So is that notwithstanding language used in this legislation to separate it from those already existing laws that we already have on the book?
Ms. Ansonia?
The bill doesn't use the notwithstanding language, but it does say except as provided by in those other instances. So in that way, it's deferring to other statutory law, case law, or court order.
Very good. Members, anyone else, any other questions for legal before we go back into session?
Yep.
All right, seeing none. And any follow-up to that, Chairman Payson? If not, I'm going to go to Representative Powell. He has a question.
Thank you, Mr. Chairman. And we talked about this sponsor in the subcommittee. And my concern here is, you painted a very rosy picture that I would hope would normally take place in parents supporting the decisions of their children. But my concern is for those situations where children are not getting the emotional support from their parents that they need, and this is oftentimes the case, and specifically for children who are going through very difficult decisions in life, that might find that themselves to not having the support of their parents, and so that's my concern with this legislation, is that always we don't find situations that are quite as picturesque as you laid out. And so I want to protect those children who feel like they are in a situation where they need the help of others and need to reach out to get that support, especially emotionally. So for that reason, I can't support this legislation. Thank you.
Chairman Payson, any follow-up?
Absolutely. Thank you, Mr. Chair. So I would just fundamentally 100% disagree with the notion that my child could come up with something in their adolescence that I don't need to be a part of. And if it's something that I personally believe is dangerous to them, 100% I reserve the right to say, this is dangerous for you. This is not the avenue you need to be choosing in life. And I want the ability, if somebody comes behind me, a teacher, a doctor, somebody of authority, and says, don't listen to your parents on this, you listen to us, and we're going to affirm you in this bad decision, well, in this decision, however they want to say it. That's my role. I'm the parent. I know the child, and I'll be the arbiter of if they've made the good decision or bad decision, and I will steer my child what I believe is right, not what society, not whatever's in vogue at the time, not what this counselor thinks, but I'm the daddy or the mom. We're going to decide what's best for the child.
Representative Powell, you're recognized.
And again, I'm not saying this is a personal reflection on you. I'm just saying my concern is that often I've heard of cases where unfortunately parents aren't making the best decisions for their children. And so if those kids and those children find themselves in an unfortunate situation, they have others that in the community and trusted people they can talk to and hopefully, work through those issues with. So again, I appreciate you personally and what you're doing, but I have concerns about the bill because of sometimes parents aren't always acting in the best interest of the child. Thank you.
Chairman Payson, any follow-up?
Thank you, Mr. Chair. And the only thing I would say back to you is your personal belief of whether that parent did right or wrong is immaterial to me. What society thinks of whether that parent did right or wrong is immaterial to me. We believe that the parent is the fundamental right to decide what's best for that child. And so as political winds change, as things come in and go, any of us sitting up here could think something's all right or normal or not normal for a child and judge a parent. But at the end of the day, unless the parent has presented themselves to be a danger to that child, they reserve the right to steer that child's emotions, spiritual health, mental health, physical health, where they believe is right.
Representative Powell? Representative Powell, you recognize. I apologize for the interruption.
That's fine, Mr. Chairman. Again, we have protections in our laws because oftentimes we find situations where parents are not acting in the best interest of the child. And you reference one where, you talk about abuse. And there are reasons we have laws in the books for protecting children who are victims to abuse. And I know you're saying that's not included in here, but just another example of why parents, we have protections in our law, are not always acting in unfortunately, some parents in the best interest of the child. So just wanted to clear that up. But I appreciate, again, your personal devotion as a parent. So thank you.
And thank you. Representative Payson, any follow-up? Okay, members, excuse me, I have Chairman Grills on the list. You recognize, sir.
Thank you, Mr. Chairman. And Chairman Faison, thank you for the bill. I understand exactly where you're coming from, and I believe I agree with you on almost every point that you've made so far. Last year, we had a task before us as soon as we got here, and that was Leader Lambert carried HB1, and several of us supported that. Is there anything in this bill that would potentially or could potentially undo any of the efforts that were put forth last year? Because I do not believe that would be your intention, but I just want to make sure that that's not going to have a unintended consequence.
Chairman Faison, you're recognized.
Thank you, Mr. Chair. Excellent question. And because of the questions that came up through Representative Bolso and other people in the subcommittee, I went and worked with the Attorney General, with his attorneys, and they actually helped me craft the language that wrote the amendment that writes the bill to make sure that there is nothing contradictory to House Bill 1 from last year. It works in parallel with it.
Chairman Grills.
Thank you, Mr. Chairman. And just for the record, though, your intention is to not do anything that would harm that bill. Is that correct?
Chairman Faison.
Thank you, Mr. Chair. Absolutely not. That's why we work so hard and diligently to make sure that we work parallel with that bill.
Thank you for clarifying.
Very good. Members, that's all I have on the questions for the sponsor at the moment. We do have some folks that have signed up to testify. So without objection, we'll go out of session to hear from our guests. And we can bring up Bernadette Padger. Ms. Padger. And then I have Connie Reguli. If you want to come up and for Connie as well, I think there's enough seats. And then I have Amy Miller as well in opposition to this piece of legislation. I was going to see if everyone could just come up. Oh, there she is. Okay. And ladies, what we'll do is I'll just start on this end here with Ms. Padger. We'll work our way down. We'll have 3 minutes apiece. Unlimited time for questions. So if you would, ma'am and ladies, just make sure when it's your time to speak, make sure your red light's on in front of you, and you'll have 3 minutes. So we'll get started as soon as you're ready.
Okay, thank you so much. Hi, my name is Bernadette Pager, and today I'm here as the Tennessee Director of Stand for Health Freedom, a national nonprofit organization fast approaching 750,000 members and 10,000 of them in Tennessee. Calvin Coolidge once famously wrote, "It is much more important to kill bad bills than to pass good ones," and I heartily agree. Later in life, Coolidge said, "Don't hurry to legislate." And that is what I am imploring of you today. Do not pass this bill. Do not be in a hurry to legislate family and parental rights, or you'll risk putting troubling language into Tennessee code. Family and parental rights are too important to not get it right. Personally, I believe these God-given rights and the proper place for the General Assembly to acknowledge them is in a resolution, not a law that can be misinterpreted, misused, or repealed. I am here today hoping that the will of this committee is to be very certain that no troubling language moves forward. I provided each of you with a list of my major concerns, and if you didn't get it from your office or as you came in today, I've got extra here if you would like them. But I'm going to address one in particular right now. In the bill, after a list of parental rights in Section C, including educational and medical decision-making rights, the bill says this section does not apply when A, a parent of the minor has given blanket consent authorizing the person or entity to perform an activity listed in subsection C. So why is this so troubling? When are parents asked to sign blanket consent forms? Unfortunately, in many places, including school, medical offices, sport organizations, clubs, and more, the agreements may list a few particulars that include blanket language such as, and anything else deemed necessary. So a parent thinks they agreed to give the school their child aspirin, but they actually agreed the school could give their child an ADHD or depression drug. According to Law and the Physician, a Practical Guide published in 1993, quote, the worst solution to documenting informed consent is the form that blankets all possibilities. The typical blanket form recites that the physician and his or her designees may do what they think is necessary. These forms usually contain language about how the physician has discussed the treatment with the patient and that the patient has had an opportunity to ask questions. Such a form may protect the physician from accusations of battery. As the sole record of consent, these forms are worthless, unquote. If blanket consent forms are worthless to the physicians, they are even worse for parents. They are sold as convenience to parents, but they rob parents of the very rights this bill purports to protect, and the language of this bill makes that legal. Parents should be highly cautious of signing blanket consent forms, and the General Assembly should not create a law that says a parent forfeits their parental rights if they agree to one.
Thank you. That's your 3 minutes, and we'll move on to the next person. But once again, we'll have unlimited time for questions. I believe, Ms. Miller, you're up.
I'm Amy Miller. I'm a mom, and I also represent Children's Health Defense. And I'm not going to repeat a lot of what was just said, but we have very big concerns on the terms blanket consent as well. There's a few different areas in the amendment that it's too vague. It needs to be tightened up. While the intent is good for parental rights, no blanket consent. We're absolutely against that. That opens up the door for a lot of things and then removes the ability for lawsuits or what have you. And not that we're promoting everybody to go sue, but blanket consent, that could mean anything. Absolutely oppose that.
Is that all you have?
Yeah.
Okay, thank you. Okay, Mr. Regley.
Called Family Forward, made up of parents concerned about the future of their children. I've also litigated complex issues in the Tennessee Court of Appeals over 40 times. I'd like to provide some comments on HB 2936. There are 4 changes that make this bill more consistent with state law and provide clarity as to when parental consent could be waived legally. On pages 2 and 7, the definition of parents should say legal parent, period. The word adoptive is redundant with state law because an adoptive parent is a legal parent. And the word biological is contrary to current state law, which says that a child born out of wedlock, the mother is the natural custodian. Therefore, she is the only parent with the rights of custody until the unwed father has established his right by court order. And since half of the children in Tennessee are born out of wedlock, this could cause much confusion. Also, parents whose rights are terminated are still the biological parent. On page 4, there is a section that talks about parental consent for interviewing children must be given, quote, unless, unquote. For the law enforcement and forensic interview sections, both need to add the language where there is articulable probable cause of abuse or neglect by a parent. That would protect the parent's rights as well as protecting the children. On page 8, which waives parental medical consent for a person providing emergency care, it should say life-saving care, as emergency care is too broadly interpreted. On page 4, I also agree with the other speakers that blanket consent should be removed. It is too ambiguous and too vague. With these corrections, the law is palatable. Here are some things you should know about parental rights in other states. 19 states have passed parental rights legislation stating that parenting is a fundamental right. These laws were passed over a 100-year period, with West Virginia being the first in 1931. 7 of those laws have been passed since 2021. Historically, these bills are much simpler and are not full of so many exceptions. In 13 states, a parent is a parent, period. No other person is granted parenthood. Only one state has included a blanket consent, which is Colorado, and no state except Tennessee has 6 unless exceptions. The best state bill which articulates parental rights is our neighbor to the south, Alabama, which was passed in 2023. Ideally, that would be how our parental rights legislation would be crafted. I ask that you sincerely consider the suggestions that I have made on this bill. Thank you.
And thank you for your comments. Members who have any questions for our guests? Any questions for our guests? Thank you, ladies. Appreciate you being here. Oh, excuse me. I'm sorry. Chairman Grills has a question.
Yeah, thank you, Mr. Chairman. I was just going, how much longer did you have on what you were finishing up with? Would you finish if it's just a few seconds?
I had one
Burnett.
sentence. Thank
Okay.
you. I
Very good.
appreciate it.
You're recognized, ma'am. Go
okay.
ahead.
I said, please do not pass this bill. Please provide the time to find the right language and the appropriate place within our state's legal framework to acknowledge family and parental rights.
Very good. And Chairman Grills, you're recognized.
Thank you, Mr. Chairman. And I know we understand that, I think we're all on the same page with Chairman Faison. I think we all want to do what we can to protect kids and the God-given right that we have whenever they were born to us. Have y'all sat down and talked with Chairman Faison and tried to work any of these things out? Has that been some of the conversations?
Ms. Miller?
Yes. Sorry. Yes, we sat down with him and he said that he would run the bill as is. He's gotten too far. And then we had another meeting with ADF and there wasn't a lot of conversation there, but we did have a meeting with them.
Okay. Chairman Grills?
Thank you. That's it.
Okay, very good. Members, anyone else? Any questions or comments for our guests? Appreciate you ladies being here.
Thank you.
Thank you so much. And we also have Matt Sharp. Matt Sharp? Sir, in support of this piece of legislation. Sir, if you would just introduce yourself to the committee, who you're with. Once you start to speak, you'll have 3 minutes, unlimited time for questions. Be sure your red light's on. Thank you.
Good morning, Mr. Chairman, members of the committee. My name is Matt Sharp. I'm senior counsel with Alliance Defending Freedom. Our law firm regularly represents families across America whose rights have been violated by harmful government actions. And now we're seeing Tennessee schools beginning to violate parental rights. It was recently uncovered that Nashville schools have created a gender support plan several years ago. The document asks students their preferred names and pronouns and whether the parents support the child's gender change. Based on it, school officials decide whether the parents will be informed about the children's gender confusion. HB 2396 would help stop actions like this. It's a promise to Tennessee's parents that their decisions about how to best raise their children will not be ignored or overruled by government officials. First, the bill puts strong limits on government interference with parental rights into state law. Thus, parents' decisions about their child's education, their upbringing, and their health care must be afforded great deference. Whether it's raising a child in the family's faith traditions, selecting a pediatrician, or deciding when their child is mature enough to have a phone, these decisions reside solely with the parents, not the government. It means parents can give consent for treatment, and they can also withdraw consent for treatment. All of that is going to be respected under state law. The government may only interfere with a parent's decisions when it has a compelling reason to do so, such as protecting a child from physical abuse or neglect. This doesn't change the DCS's authority to investigate abuse or neglect. And if a parent, as was brought up earlier, is denying lawful, necessary medical treatment, that's going to be neglect. And this is going to empower and still allow DCS to step in cases of abuse, neglect, and abandonment. Finally, the bill provides a legal remedy for families whose rights are violated, letting them, for example, get a court order telling the government to stop interfering with parents' decisions. Otherwise, families can be left with no recourse when the government tramples these rights. As we've heard, 17 states have passed laws like this, recognizing parental rights as a fundamental right, including North Carolina, Florida, Georgia, and several others. In passing this, Tennessee would join those states in making a strong, principled stand with parents. Tennessee has long been a leader among the states in protecting fundamental rights against government interference. includes the right to free speech with a teacher-student rights bill several years ago, freedom of religion with the Religious Freedom Restoration Act that you passed several years ago, and even other fundamental rights. Those laws all put safeguards into state code so that government officials are on notice and have their duty to respect these God-given rights. HB 2936 will simply do the same for parental rights. Thank you.
And thank you, sir. Members, do we have any questions for our guest? I have first on the list, I have Representative Capley. You're recognized.
Thank you, Mr. Chairman. Thank you for being here to testify. Could you please expand a little bit on that, the legal recourse, if you would, sir?
You're recognized. Go ahead.
Thank you. So one of the things is a lot of times parents don't have a legal recourse. So for example, if you're dealing with like the gender support plan in Nashville Public Schools, where a school official is hiding information from parents, there may be no legal recourse, no ability to get a court order requiring these records to be disclosed or requiring school officials to respect parental decision-making. We've unfortunately had that happen in several other states that do not have strong parental rights laws. For example, we've got a case going on in Michigan right now where school officials were transitioning a young girl without the parents knowing about it. In fact, they were altering school records and documents before sending them home so that the parents had no idea about it. And so this is meant to give a legal recourse so that if something like that's happening under Tennessee law and Tennessee courts, parents can go and get a legal remedy and have a court order protecting their decision-making over their child.
Any follow-up, Representative Capley?
No further questions, Mr. Chairman. Thank you.
Very good. Representative Bolso, you're next on the list.
Thank you, Mr. Chairman, and thank you, Mr. Sharp, for being here. Let me, if I could, ask you to direct your attention to the comments that we heard just a moment ago from Ms. Pager and Ms. Miller in particular. They're concerned about subsection D3A of the bill that deals with this concept of a parent being able to sign a blanket consent. So the structure of the legislation is that in subsection 3, there's a non-exhaustive list of 12 different rights that parents have. And the concern is that, well, that's all well and good, but subsection D3A is going to swallow the entire bill because schools and other governmental entities are simply going to give parents a form to sign, and parents are going to sign it, perhaps unwittingly or unknowingly, and give away all of their parental rights. What is the answer to that argument? Because it obviously, on its face, is a powerful argument.
Mr. Sharp, you recognize.
Thank you, Mr. Chair. Unfortunately, a lot of schools are already doing that. They're signing these forms. And so this is a recognition that under contract law, you can give authority, whether it's your pediatrician or someone else. But importantly, this also is going to make sure that parents, when they withdraw that consent, that decision is respected. And I think that's one of the key pieces that's missing is that a school could say, we're going to do these decisions. We're going to, whether it's the gender support plans or other things without you being involved, and there's nothing parents can do about it. This is now going to give parents that the deference that they're entitled to in the law, so that when they say, do not treat my child, do not give them this counseling that we object to, whatever it may be, now the government has to respect that. And if they don't, as Representative Capley brought up, there's now a strong legal remedy that parents can go to Tennessee courts and get their rights respected. So in many ways, this is strengthening the ability of parents to make those decisions. And when they decide, no, we're not giving a consent, whether it's to a school official or someone else, that now has to be respected. And parents now have meaningful tools to make sure that their decisions are respected.
Representative Bolso, any follow-up?
Thank you, Mr. Chairman. If I may just ask one follow-up, just to make sure I understand completely the response. If I understand what you're telling us, Mr. Sharp, it's that under existing Tennessee law, there already exists the contractual right that parents have to sign a blanket consent, so that this bill itself is not actually creating that right. It already exists. In fact, it's already been implemented in numerous occasions. But what the legislation does is it provides recourse to revoke that consent and legal recourse further down the road if that should be necessary. Is that accurate?
Ms. Sharp?
Thank you, Mr. Chairman. Yes, that's exactly right.
Representative Bolso, any follow-up?
No, thank you, Mr. Chairman.
Thank you. Thank you, sir. Leader Lamberth, you're recognized, sir.
Thank you, Mr. Chairman. And just as a question, so there are several sections in here that go through obviously parental rights, and there are a couple of sections that talk about a parent not having the right to consent to prohibited medical practices. And is that why that you feel that this does not in any way affect the legislation we passed last year that has certain prohibited medical practices within the state of Tennessee that no one can consent to, not a doctor, not a guardian, not a parent, no one. Would that be an accurate statement?
Mr. Sharp?
Thank you, Mr. Chair. Representative Lambert, that's correct. In fact, this is the language that the Attorney General's office was very comfortable with to ensure that HB1 is not impacted by this. And importantly, not only does it say that a unlawful medical treatment that a parent can't use this law, but it also deals with third parties. So if you had, for example, a gender clinic or some group like that trying to misuse this law in that way, it would prevent them as well. So this is very much like Chairman Faison said, works in conjunction with HB1 to ensure that among the lawful medical options that parents can choose, but the things that the state has said that doctors should not be doing to children, that those would not be accessible under this bill.
Leader Lambert, you recognize.
Thank you, Mr. Chairman. And there are other bills that are pending in the legislature that talk about third parties carrying children outside of this state for prohibited medical practices. Would it be your opinion that this bill would also not affect those bills?
Mr. Sharp?
Thank you, Mr. Chairman. Representative Lambert, that's correct. It would not.
Thank you.
Members, anyone else before we go back into session? Any other questions for our guests, comments? Seeing none. Mr. Sharp, appreciate you being here.
Thank you.
All right, members, without objection, we'll go back into session. And recognize Chairman Faison for any closing remarks.
Right. Call the question.
All right, members, do we have any questions? Representative Powell, you recognize.
I just want to read a resolution that was passed by Metro Nashville Public Schools. It said the Metro Nashville Public School of Education unanimously passed resolution affirming the physical, mental, emotional support of all students, staff, parents, and stakeholders, regardless of gender identity, gender expression, or sexual orientation. Want to clarify some of the testimony we heard that was inaccurate. Thank you.
Good. Chairman Faison, do you need any comment? Members, unless Chairman Grills.
Thank you, Mr. Chairman. And Chairman Faison, we had the three ladies there that asked the question about, what was the reason y'all could not come to an agreement, if you don't mind, just for clarification for the rest of the committee.
Chairman Faison, you're recognized, sir.
Thank you, Mr. Chair. Representative Grills, there are times that you get to an impasse, and after working with attorneys from our Attorney General's office for hours and hours on this, and working with the attorneys from Alliance Defending Freedom who've been in this space, I let them know that I trust our Attorney General and Alliance Defending Freedoms more than I trust their apprehension. And we're going to go with this, with the committee's indulgence. We're going to stick with what they've brought me.
Representative Grills.
Thank you, Mr. Chairman. And I have confidence in our Attorney General. I think he's a great guy and has the right worldview. And I'm tickled to death calling my friend, not just our Attorney General. But I am concerned about that blanket consent that Representative Bolso, he brought up earlier. But anyhow, just thank you for your efforts and trying to be on the right side of this issue.
Chairman Faison, any follow-up, sir?
I'd like to clarify with the whole blanket consent. I have 2 children in public school. When I enrolled my children in public school, I give blanket consent for them to be taught what the teachers teach there. That's the notion of what we're doing. It's understanding that I understand that they're going to be taught things that I disagree, that's in the curriculum that I disagree with. But me putting my children there, that's given blanket consent. Doesn't mean I agree with everything, but what it does mean is it stops the teacher from coming around and saying, well, your daddy's or your mama's wrong on this, or that. That gives me repercussions. So, well, wait a minute, you're fine to teach them, but you can't pull them aside. You can't coerce them to be convinced of what you're saying. They can pass the test, but you don't get to have impact on their worldview, on their makeup of who they are.
Thank you. Leader Lambert.
Move previous question.
Very good. Previous question's been called. Any objection? Seeing none, looks like we're ready to vote to send House Bill 2936 as amended to calendar and rules. Members, all those in favor say aye.
Aye.
Opposed, say no. Ayes have it. If you want to be recorded as a no, see the clerk. That brings us to item 2. House Bill 2839, that's by Representative Towns. He's asked for that to be rolled 3 spaces, members. Any objection? Seeing none. Item 2, House Bill 2839, rolled 3 spaces. Brings to item 3, House Bill 2117 by Chairman Powers. Sir, you're recognized. I don't see an amendment on this piece of legislation, so you're properly recognized.
Thank you, Mr. Chairman and committee. On House Bill 2117, last year we passed a bill which became Public Chapter 479, which prohibits a state or any local government entity from adopting or implementing policy recommendations that deliberately or inadvertently infringe or restrict private property rights without due process. As many as may be required by policy recommendations originating in or traceable to the United Nations or a subsidiary entity of the United Nations. It was a good law, but it really had no teeth to it. House Bill 2117 requires, as part of the local government's annual audit, that the executive of the local government entity to present a written confirmation to the comptroller of the Treasury certifying that the local government entity has not sought or received a grant or intentional pursuit of a policy relative to Agenda 21, the 2030 Agenda for Sustainable Development, Net Zero Goals for 2050, or any other international law or additional plan of action that violates the U.S. Constitution or the state constitution. House Bill 2117 authorizes an individual who believes that a political subdivision has violated present law to bring a private right of action in a court of competent jurisdiction. And with that, Mr. Chairman, I renew my motion.
And thank you for that explanation. Members, any questions for Chairman Powers? Seeing none, are we ready to vote? Any objection? Seeing none. All right, looks like we're ready to vote. Send House Bill 2839 to calendar and rules. All those members, excuse me, I about sent Representative Towns' bill out. All right, we're voting. We're not send item 3, House Bill 2117 by Chairman Powers to calendar and rules. All those in favor say aye. Aye. Opposed, say no. Ayes have it. When we record as a no, see the clerk.
Thank you, Mr. Chairman. Committee.
Very good. And that brings us to item 4 that had been taken off notice, as was mentioned previously. Brings to item 5, House Bill 2647 by Chairman Reagan. So you're properly recognized.
Thank you, Mr. Chair. With the committee's indulgement, I asked to roll this 1 week.
Committee, any objection? Seeing none. House Bill 2647 rolled 1 week. And members, that brings us back to item 2, House Bill 2839 by Representative Towns. Without objection, let's roll that 1 space. Without objection, 1 space. Chairman Reagan, that brings us back to item 6, House Bill 2859 by Chairman Reagan. You got a motion and a second, sir, and I see House Amendment 15820 attached to that. Would you like to move forward?
That's correct, sir. I ask for to adopt the amendment.
Very good. You got a motion and a second. Does it reroute the bill?
Yes, sir.
Okay, members, we want to go ahead and get that on, get it properly formed. All right. Motion on amendment. Got a second. All those in favor of adopting House Amendment 15820 to House Bill 2859, say aye. Aye. Opposed, say no. Ayes have it. Now, sir, we're back on the bill as amended. You're properly recognized.
Thank you, Mr. Chair. This bill extends the limits of duty of care under the current law to owners of private parks who enter into a cooperative agreement with public utility for the use of public utility land in conjunction with the owner's land. Under current law, these protections apply to many other situations where the owner of the land invites public to enjoy the state's natural resources. Some examples: an owner of land leased to a state or any agency thereof, an owner of any land which is subject to conservation easement or public use easement, granted to or acquired and held by the state, any agency thereof, that is in TCA 11-10-102 and 103. Essentially, what this bill does is apply that if the landowner makes that park available to the public, the liabilities associated with that are no greater than they are for a public park. However, it does not remove the liability for negligence or willful and wanton misconduct. With that explanation, I stand ready to answer questions and ask for your support.
Very good. Members, with that explanation, does anyone have any questions or comments for Chairman Reagan? Are we ready to vote? Question's been called. Any objection? Seeing none, looks like we're ready to vote. Send House Bill 2859 as amended to calendar and rules. All those in favor say aye. Aye. Opposed, say no. Ayes have it.
Thank you, Mr. Chair and Committee.
Thank you, sir. And once again, that brings us back to Representative Towns, House Bill 2839. And we're on item 2, Representative Towns, House Bill 2839, sir, and you've got a motion in a second. You're properly recognized.
Thank you, Mr. Chairman, members.
And you do have a Ms. Tucker on the list to testify on this bill. So if you want to just give a brief explanation, you can. If not, we can go out of session and hear from
If
her.
she's here, I'd like to go out of session. Some of them were not able to make it because of storming back in Jackson. Ms. Hill, the one that testified the last time, the attorney and the other financial advisor.
Okay.
So I'd like, if there's somebody here, that wants to.
I have an objection to going out of session to hear. Would you like to hear from, are you asking that we hear from Representative Towns first? Okay. Representative Towns, if we would you just give us a brief explanation? I believe
No problem.
Representative Parkinson would like to hear one as well.
Okay, no problem. Well, what it is, thank you, members. Motion is second. I got my spectrum. The bill itself, House Bill 2839, what the bill is seeking to do is to protect the retirement funds of, citizens, okay? And that's essentially what it does. It seeks to protect those retirement funds from creditors being able to go in and sue you for those funds. Your IRA, whatever money you have set aside for your retirement, this, that, and other. That's what it simply seeks to do. And for years, Tennessee have been able to rely on certain retirement plans, whether the state retirement, such as teachers have available, or certain private retirement plans specifically exempt from the claims of creditors and from subpoenas under TCA 26-2-105. House Bill 2839 seeks to amend TCA 26-2-111 to clarify that it does not, provide the TCA-26-105, rather that TCA 26-2-11 provides, as its title implies, additional exemptions from several miscellaneous type funds. Our Court of Appeals has determined that the lawyers and the trial courts have convinced that they were wrong, finding that TCA 26-2-105 is more specific than 26-2-11, and that the interpreted 26-2-11 to remove the protection of the 26-2-105. At that point, retirees can access their funds, and that the very intention of the legislature in acting the 26-2-105 in the first place, our Supreme Court denied the creditor's application for permission to appeal. The legislative history, as well as the Attorney General formal opinion, clearly showed that the intent to absolutely and completely protect IRAs and other specific retirement plans from creditors. That's essentially what the bill does. It's trying to protect your money from people going in to sue you, your retirement funds.
And thank you. That's next on the list. I do have Chairman Todd on the list.
Thank you, sir. And I appreciate you bringing this legislation. I think members might see that I co-sponsored this. Actually, a young lady in my district brought this to me who's an attorney, and they've had experience in this area where a court ruled basically opposite of what state law says and then was overturned on appeal. So this is clarifying that these protections are already in place. Just makes it very, very clear. So I appreciate your consideration.
Thank you for that. Representative Towns, any follow-up for that? Okay.
No, sir.
Leader Lambert, you're recognized. You're next on the list.
Mr. Chairman, I'm at the will of the committee. I had a motion to make, but if Chairman, obviously, if you want to hear testimony, if anybody else does, I'll hold off on the motion I was going to make.
Very good. And I have next on the list, I have Representative Bricken.
Thank you, Mr. Chairman. Certainly, I'm not by any means an expert here, but I thought all IRAs, Roth IRAs, 401ks were protected by federal statutes from any type of garnishment, encroachment, or whatever you want to call it. So, I never thought there was a problem here. So, again, I assume that federal law would override state law, or only state law could supplement federal law. But I really didn't think there was a problem.
Very good. Next on the list, Representative Parkinson, you have a motion to make.
I do, Mr. Chair, being that I wasn't sure if it was Representative Boso spitting out those codes or Representative Towns. I was a little confused, so I'm gonna ask that we go out of session so we can hear from the witness.
Members, let's, without objection, we can go out of session here from Miss Tucker. Darlene Tucker, ma'am, are you here? Heard the storms impact our availability. Okay. And then, so we're still in session. Leader Lambert, you're next on the list. I saw
Move
your hand
previous
first.
question.
Previous question's been called. Any objection? Previous question? Seeing none, all those in favor of sending House Bill 2839 to counter rule, say aye. Aye. Opposed, say no. Ayes have it.
Chairman.
Brings to item 7, House Bill 2384 by Chairman Howell. So we've got a motion and a second, and I'm looking at House Amendment 15571.
I believe that's correct.
You got a motion and a second. Would you like for us to go ahead and adopt it?
Please.
Very good. Question's been called on the amendment. All those in favor of adopting House Amendment 15571 to House Bill 2384, say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bill as amended, and you're properly recognized, sir.
Thank you, Mr. Chairman. Members, this is a clarifying bill that addresses school bus contractor insurance. There are several school boards, LEAs in Tennessee, that contract out their transportation to take the students to and from school. There is an AG's opinion that says independent bus contractors cannot be covered under government tort liability. And so HB 2384 seeks to clarify what additional insurance an independent bus driver contractor needs, because through the years, there have been conflict and misunderstanding over liability insurance when there have been cases following an accident, and the contractor thought they had liability insurance covered by the LEA. That is not the case. And so this seeks to clarify that an LEA, when entering into a transportation contract with a contractor, will help that bus contractor make sure they have the proper liability insurance coverage in case of an accident. And the bill also clarifies that the LEA cannot be the secondary insurer for the contractor. That's all the bill does.
Very good. Members, we have any questions for Chairman Howell? Any questions? Question's been called. Any objection? Seeing none, looks like we're ready to vote to send House Bill 2384 as amended to calendar and rules. All those in favor say aye. Aye. Opposed, say no. Ayes have it.
Thank you, Chairman and committee.
Thanks, sir. That brings us, members, to item, excuse me. Chairman Gross, you're recognized.
Thank you, Mr. Chairman. And while we're waiting on Representative Terry to get here for the next bill, I was wondering how come Representative Towns had to carry that bill for you, Chairman Todd?
Chairman Todd, you're recognized.
Thank you for that very important question. I perceived that I actually was carrying it for him. I just let him talk.
All right, members. And with regards to item 8, we are on item 8, House Bill 2372. As I understand it, Chairman Terry has asked for that bill to be rolled for 1 week. Is there any objection to that? Seeing none, House Bill 2372 rolled for 1 week. And same posture, item 9, House Bill 2434. Chairman Terry has also requested that to be rolled for 1 week, members. Any objection to that? Seeing none, all those favors, excuse me, without objection, rolled for 1 week. That brings us down to item 10. And there he is, Chairman Rudd, sir. House Bill 1259. And I'm looking at House Amendment 17426, sir. All right, members, we've got a motion, second. We want to go ahead and adopt that amendment. Any objection to that? Seeing none, all those in favor of adopting House Amendment 17426 to House Bill 1259, say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bill as amended, and you're properly recognized.
Thank you, Mr. Chairman, committee. What this legislation has amended is the Tennessee Anti-Squatting Act. It addresses a very serious issue of people moving into abandoned properties without ever having permission or of the property owner, never having a lease, or never owned the property. They move in and claim the property is their own. They claim to have a lease that can take as long as 2 years to evict them and cost the property owner tens of thousands of dollars, and also lost revenue if it happens to be rental property. This has become a runaway epidemic in Georgia and Florida and in some northern metropolitan areas. A similar legislation is being passed in neighboring states, and we run the risk of illegal squatters coming here in larger numbers than they already exist. What this legislation does is it gives our sheriffs and our courts a streamlined ability to restore possession of residential property to its lawful owner when being unlawfully occupied to protect their property rights. It also assists law enforcement to put a stop to any criminal activity such as might be happening on the property or what it's being used for. How it works is the following. The property owner files a complaint and fills out a form under the penalty of perjury with the sheriff, verifying that that they are the property owner, and the conditions of which the squatter is unlawfully occupied must be filled out on a form. The sheriff then verifies with the register of deeds that they are indeed the legal owner. Once verified, the sheriff would immediately serve a notice to vacate and return the possession to the owner. The sheriff is entitled to the same fees and reimbursement that already exist in law. They must agree with the person in question that is not the co-owner, renter, previous owner, or that any lease provided is unlawful. The occupant is fraudulent. The legislation also states the sheriff and the property owner and their agents are not liable unless removal is unlawful. If a civil suit is filed, it provides it for an expedited process. Similar legislation recently passed in Florida unanimously by all parties involved. It is my hope that this nonpartisan legislation, which solves a very serious problem that is coming to Tennessee, will also have the support of both sides. Thank you.
And thank you for that explanation, sir. Members, I have Chairman Grills on the list.
Yeah, thank you, Mr. Chairman. And I just find this ironic. This past weekend, I've had two constituents call me with this very issue, and they're fearful of it, and what's going on in Florida and how they've taken care of it. I appreciate the foresight that you've seen to make sure Tennessee's on board. So thank you for that.
And Atlanta, it's epidemic proportions. It's caused a massive chaos, and the Georgia legislature is taking up similar legislation now.
Very good. Any follow-up, Chairman Grills? Okay. Representative Capley, you're next. Question's been called. Any objection? Seeing none. All those in favor of sending House Bill 1259 as amended to calendar and rules, say aye. Aye. Opposed, say no.
Thank you, and the property owners of Tennessee say thank you.
Thank you, sir. All right, that brings us to item 11. Representative Chisholm. I saw him earlier. Okay. Leader Lambert, you recognize.
Make a motion, roll 1 week.
Very good. Motion's been made. Any objection? Seeing none. House Bill 2046 by Representative Chisholm. It will be rolled for 1 week. That brings us to item 12, which was disposed of earlier. That House Bill 2644 had been rolled for 1 week. The sponsor's request. Brings to item 13, House Bill 1258 by Representative Vital. Sir, you have a motion and a second. And I see two amendments here, sir. Is there any, the last one that was filed was 17481.
That is correct, Mr. Chairman. 017481 is a technical correction. It was pointed out in subcommittee, and drafting code 017175 rewrites the bill.
Very good. Members, without objection, if we could just roll those amendments into one, maybe cleaner without objection. And then, sir, if you would go ahead and just explain, you said one rewrites the bill, and the other one was a technical amendment, which is one amendment now. Members, we will go ahead and adopt that onto the bill. Motion has been made, second. All those in favor of adopting now.
Thank you, Mr. Chairman. House Bill 1258 was brought to me by the Chancellor in Hamilton County. It
Very
deals
good.
with notice.
Hey, Representative Vital, let me fix what I've messed up.
Okay.
Members, we can just adopt these amendments separately, and then once they're adopted, we can roll them into one. So all those in favor of House Amendment 17175, which rewrites the bill, say aye. Aye. It's adopted. All those in favor of House Amendment 17481, which makes a clerical addition, say aye. Aye. It's adopted. And without objection, we'll roll those into one. Now you're probably recognized, sir, on the bill as amended.
Thank you, Mr. Chairman. Committee, House Bill 1258 was brought to me by the Chancellor in Hamilton County. It deals with notice during the settlement of an estate. 1258 clarifies existing code and simply adds that a personal representative must notify a residuary distributee that they can file an exception to a claim. It sets the time frame, 60 days, and a process in which a personal representative can notify those involved. With that exception and explanation, I'm happy to answer any questions.
Very good. Members, any questions for Representative Vital? Any comments? Seeing none. We ready to vote? Looks like we are. Without objection, all those in favor of sending House Bill 1258 as amended to calendar rules, say aye. Aye. Opposed, say no. Ayes have it.
Thank you, Mr. Chairman. Thank you, committee.
Very good. Thank you, sir. Brings to item 14, House Bill 812. So we got a motion and a second. And I do see House Amendment 13999.
Yes, Mr. Chairman, but before we get into it, we've had some voices reach out to us that have some issues, both negative and positive, that want to add into this bill. So at this late stage in the session, we've talked with the Senate sponsor. We're just going to take this off notice and work on it over the summer and come back next year.
And thank you for that, sir. Members, any objection? Seeing none. Off notice. Sir, and you also have item 15, House Bill 2420. You have a motion and a second, and I see that your latest amendment filed was 17190. Would you like to move forward with that?
Yes, please.
Does it rewrite the bill?
It really is a technical change, but it does rewrite the bill because just to make it cleaner, we redrafted the entire amendment to make one minor change.
Okay. Members, we'd like to go ahead and adopt this amendment. So Representative Barrett can explain his bill. Motion, second. All those in favor, House Amendment 17190, say aye. Aye. Opposed, say no. Let's have it. Now we're back on the bill as amended, sir. You're recognized.
Thank you, Chairman and Committee. This bill seeks to address some of the concerns that we've seen in the legal community as it relates to our older folks in our across Tennessee that have become targets for either abuse, whether that be physical abuse or financial exploitation. And so I think to a man and a woman here, we all want our parents and older relatives to find love late in life, but occasionally they're made to be targets. And so what this bill addresses is going to do is going to create a legal process whereby surviving spouses can be found by a court to have entered into a marriage with an elderly person or disabled adult under deceptive or financially exploitative circumstances. Currently, there's not a vehicle under the law for surviving spouses or family members to be able to address this issue. So if this bill passes, becomes law, a court determines that a surviving spouse is engaged in a marriage as part of a scheme that would involve abuse, neglect, or sexual abuse, financial exploitation, or theft of an individual's property, then certain rights and benefits typically granted to a surviving spouse would be forfeited. Family member would have to demonstrate to a court by preponderance of the evidence that the marriage was procured under exploitative circumstances, and the court must make a determination as to the elderly person or disabled adult's legal capacity at the time that they entered into such a marriage. And then we've put a 4-year statute of limitations for this act to be brought, or this cause of action to be brought. And with that, I stand ready for questions.
And thank you for that detailed explanation, sir. Have on the list Leader Lambert.
Move previous question.
Previous question's been called. Any objection? Seeing none, let's ready to vote. Send House Bill 2420 as amended to calendar and rules. All those in favor say aye. Aye. Opposed, say no. Let's have it.
Thank you, Chairman and Committee.
Very good. Here's item 16, House Bill 2310 by Representative Ritchie. Sir, I'm looking at the latest amendment I have is 16253.
That is correct.
That's correct. Members would like to go ahead and adopt that amendment. Very good. All in favor of adopting House Amendment 16253 to House Bill 2310, say aye. Aye. Opposed, say no. Ayes have it. Back on the bill as amended. You recognize.
Thank you, Chairman and Committee. House Bill 2310 as amended will end up creating a Class C felony for anybody who takes a minor outside of the state of Tennessee for the purpose of having transgender procedures. A parent can end up taking a minor out of the state. It's written clearly into this bill. A parent or a guardian could give permission to somebody else. That's clearly written inside of this bill. But if somebody takes one of our kids without the parent or guardian's permission, they would be creating a Class C felony. And it also creates the civil action that could end up being taken as well when we get down to subsection E. And with that, Chairman, I stand by for any questions.
Thank you for that explanation, sir. Members, I have anybody that wants to ask Representative Ritchie any questions or have any comments on this bill? Vice Chair Jernigan, you're recognized.
Thank you. So if it's without permission, would that not just be kidnapping?
Representative Ritchie, you recognize, sir.
Correct. It would be similar to kidnapping, but this right here would create a more severe penalty. It's Class C felony.
Oh, it's more severe than kidnapping. Is that what you're saying?
Yes.
Oh, okay. It's the same. Okay. All right.
Very good. Does that answer your question, Vice Chair Jernigan? Okay. Don't want to confuse anyone. Members, any additional questions, comments? Seeing none, we ready to vote? Looks like we are. All those in favor of sending House Bill 2310 to Finance, Ways and Means, say aye. Aye. All opposed, say no.
Thank you,
Ayes
Chairman
have
Committee.
it. We record as no. See the clerk. Item 17, Representative Slater, sir. House Bill 2665. You have a motion and a second. Looking at House Amendment 15516.
That is correct. Thank you.
Greg, is there rewrite the bill?
Yes.
Okay, members, we'd like to go ahead and attach this. Very good. We got a motion and a second. Any objection to voting? Seeing none. All in favor of adopting House Amendment 15516 to House Bill 2665, say aye. Opposed, say no. Ayes have it. Representative Slater, you're recognized.
Thank you, Mr. Chairman and committee members. As amended, House Bill 2665 does two things for families when a juvenile has been arrested for an alleged delinquent act. First, the juvenile must be allowed at least one telephone call per day with the child's parent, guardian, or legal custodian per day. Secondly, the juvenile must be allowed at least one 30-minute in-person visit with the child's parent, guardian, or legal custodian per day. This requirement is only for that period after arrest and prior to adjudication. And with that, I stand ready for questions.
Very good. And thank you for that explanation, sir. Members who have any questions for Representative Slater? Any questions? Representative Bricken, you're recognized, sir.
Thank you, Mr. Chairman. Just for clarity, what are the current rules for a juvenile for being able to have access to their parents or by phone or by visitation?
Representative Slater, you're recognized.
Thank you. Thank you for the question. There's some inconsistencies when it comes to juvenile detention centers, so we want to make it clear what the requirements are in statute.
Representative Bricken, that answer your question?
That's fine. Thank you.
Any additional questions, sir? Okay. All right. Members, anyone else? Questions, comments before we vote? Are we ready to vote? Any objection? Seeing none. Looks like we're ready to vote to send House Bill 2665 as amended to calendar and rules. All those in favor say aye. Aye. Opposed, say no.
Okay.
Ayes have it.
Thank you, committee.
Thank you, sir.
That's great.
All right. That brings us to item 18 by Vice Chair Jernigan.
Yes.
Sir, you have a motion and a second. I don't see an amendment, any amendments filed. So you're
No,
properly
there's-
recognized.
There's no amendments needed for this one. Okay. So, well, members in 1829, the General Assembly enacted a law that marriage cannot be contracted with a linear ancestor or descendant, nor the linear ancestor or a descendant of either parent, nor child of a parent, nor lineal descendants of a husband or wife, nor the husband or wife or a parent of lineal descendant. There was an opinion issued October 24th, 1960, that the Attorney General determined that this statute does not prohibit marriage between cousins. So by substituting nor the child of a grandparent with nor the lineal descendant of a grandparent, it would effectively prohibit marriage between first cousins. And while I do not know the intent of the 18th General Assembly, and that we do have an opinion, I think it's safe to say in 2024 that we should probably close this loophole, as I think it's a public safety matter, public health matter. With that, I think I'll answer questions.
Very good. Members, you've heard the explanation. Representative Capley, you're recognized.
Thank you, Mr. Chairman. To the sponsor, where did you get this piece of legislation? Did you have a constituent bring this to you, or?
No, okay, I'll tell you with the genesis of it. In 2008, my wife and I were looking to get married, and we went to the clerk's site. And we went to frequently asked questions. And I kid you not, the very first question was, can you marry your cousin in Tennessee? And the answer was yes. And so over the years, we kind of laughed about it, and I'm really sad. Oh, there you are. Because because when I announced that I was retiring, I'm going to put this on Leader Lambert. Leader Lambert said, you should always run that bill you've always wanted to run. And I was like, that's that first cousins bill. So there you go. That's why it's coming, and I think it's far time time we should do this. See? I threw you.
And thank you, sir, for that explanation to answer that question. Representative Capley, any follow-up?
Please, to the sponsor, this is not going to be your final bill, is it?
Vice Chair Jernigan, you're recognized.
That'll be up to Chairman Doggett tomorrow or today, but possibly, but I hope not.
Representative Capley. Fair enough. Representative Powell, you're recognized, sir.
This is maybe a question for legal. Is it possible to name two bills after someone?
Oh, no.
Sir, would you like us to expand on that or dig deeper?
Well, I'm wondering if we can't name it after another bill after Representative Jernigan, maybe we can name it after his favorite cousin.
Oh, all those are unfriendly amendments.
Representative Bolswell, you're recognized.
Thank you, Mr. Chairman. And, oftentimes we debate whether we should actually say something because we might regret something we say. And I'm going to go ahead and say it. Chairman Jernigan, I'm going to support your bill, but it is with a little bit of sadness because, my grandparents came over to this country through Ellis Island in Italy back in the 1920s. My grandmother was named Sandrella De Luciano, and my grandfather was named Antonio De Luciano. And they settled in Lorraine, Ohio, right south of Lake Erie, next to Cleveland. And they were first cousins, but they couldn't get married in Ohio. So back in 1924, they actually came down to Tennessee to get married. But for the existence of the current law, I would not be here. But despite that, I think it's good legislation, and I intend to support
There's
it.
an opening there, isn't there?
All right, Leader Lamberth, you're up. Teed up.
I'm not real sure what to say after that, but I will say this. I'm just gonna just disregard what was just said and appreciate that family history. But I will say, you all have heard of the 49ers. That's a popular team out there. But if you came into the legislature in 2012, raise your hand up right here. Okay, the 2012ers here. So the advice I gave was not necessarily on this bill, but I did say if there is a bill that you've always wanted to pass, then now's the time. You should put it forward. You're retiring. You've served for 12 years down here, and we wish you well. But it was not specifically on this
I
bill.
should have clarified.
Yeah, and by the way, he took me up on this because I think he filed 5 or 6 bills he'd been sitting on for several years. This isn't the only one that he was like, man, I really want to get that done before I leave. So anyways, fully support the legislation. I think it's a good idea. Irregards of those fine members that may or may not be with us had this law been in effect 100 years ago.
Very good. Representative Parkinson, you're recognized, sir.
Thank you, Mr. Chair. I too, like my colleague, kind of shorter words here, but I can say this to my colleague Boso. You have just broken the internet, so expect it. Yep.
Again. All right, members, any questions or comments before we vote? Seeing none. All those in favor of sending House Bill 2041 to calendar and rules, say aye.
Aye.
Opposed, say no. Ayes have it. Passes unanimously.
I'm not looking for it.
Members, that brings us to item 19, which was disposed of earlier, 2508. That's been rolled for 1 week. Now down to item 20, House Bill 2704 to Chair Lady Littleton. Chair Lady, you also have House Amendment 14357. And you've got a motion and a second on that. Members, we want to go ahead and vote to adopt that amendment. Looks like we do. All those in favor of House Amendment 14357, say aye. Aye. Opposed, say no. Now we're back on the bill as amended. Chair Lady, and you're recognized.
Thank you, Mr. Chairman. This bill, as amended, requires the Department of Children's Services, the county medical examiners, the chief medical examiners, and facilities that perform autopsies to establish policy and procedures to prioritize the completion of final autopsy reports for fatalities of children in DCS custody or children who are subject of ongoing investigation by protective services within 45 days preceding the fatality, and for the children whose fatality resulted in an investigation of the safety and well-being of another child in the home. What this come from the second look, I don't know if I said that or not, but we find in our reports that if there's a fatality, that sometimes it could take up to 3 years for the autopsy to come back. And there could be other children in the home that, especially if it's unclear if it was child abuse or not. So we feel like this would help if the other children that are in the home and at least give the parents some kind of closure as well. So that's what this bill does.
And thank you for that explanation, Chair Lady Littleton. Members, any questions for our Chair Lady? Questions have been called. Any objection? Seeing none. All those in favor of sending House Bill 2704 as amended to calendar rule, say aye. Aye. Opposed, say no. Ayes have it. That brings us down to item 21, which was disposed of earlier. It's been taken off notice. That was House Bill 1349. Down to item 22, which was House Bill 2001, is rolled for 1 week. We disposed of that earlier. And that brings us down to item 23, House Bill 2002, which is my bill. Chairman, Vice Chair Jernigan, sir.
Thank you, Chairman Farmer. We are on House Bill 2002.
And sir, I have House Amendment 17731 I'd like to adopt.
The amendment's been motioned and second. Without objection, we'll put it on the bill.
Very good.
Okay, Chairman Farmer, you're recognized.
Thank you, members. What this bill does, if we remember back, I don't know, when I first got elected about 10 years ago, there was a lot of judicial and just redistricting talk about the state. As we move forward, 12 years removed now, as we look at the empirical historical data, going back to 2002, it's clear that that district, the 30th Judicial District, has been overjudged by 2, if not more, since then. And so what this bill does, it removes 2 judges. It removes Part 7 and Part 9 from the 30th Judicial District and places those respectively in the 4th Judicial District and the 19th Judicial District. And with that, Mr. Vice Chair, I move passage.
Thank you. You've heard the explanations. I've got Representative Capley first. No? No? Okay. All right. Capley's out. Grills, you're up. No? Okay. Leader Lamont, you recognize.
Thank you, Mr. Chairman. And Mr. Chairman, I sent this to you just a moment ago. It's my understanding that one of those 2 judges, obviously one of the judges has been appointed to the Tennessee Supreme Court. The other judge has indicated through her lawyer via letter, we have a joint convention on Thursday to remove that judge. She has indicated through a letter that she wishes to resign immediately. I'm waiting for that to be an actual official resignation. And it may be that one of these 2 seats may be vacant as of right now. So just wanted to say that publicly, that, that may happen sooner than was anticipated.
Chairman.
And if I may follow up that's a good point, and I really appreciate you bringing that up, Leader Lambert. So these seats are, and/or one of them may be vacant any moment now. The other one will be vacant in a short period of time. So we are not moving a seat where there's a judge currently sitting that may affect their career or retirement or family in any way. So I think that's very, very important to point out that in this, when considering this piece of legislation. Thank you, members.
Thank you, Chairman. Representative Grills asked to be rolled 1 space. Representative Grills, you recognize.
Question on the bill?
Second.
Question on the cause. Objection. We got. Right. All right. We'll vote on the question because I put my hand up as well. That's 3. And it's a voice vote on the question. I did. Okay, just a voice vote on the previous question. All those in favor of the previous question say aye.
Aye.
Those in favor, negative? No. Ayes have it. Previous question prevails. We're voting on House Bill 2002. All those in favor say aye.
Aye.
Those opposed? No. The ayes have it. And Chairman, you're going to Finance, Ways and Means.
Thank you, Mr. Chair.
That brings up item number 24, which is House Bill 2003 by Chairman Farmer. Got a motion and seconds in the proper. You got an amendment, sir?
Yes, 15762.
Have a motion on the amendment?
Second.
Got a motion and second on the amendment on the bill. Chairman Farmer, you're recognized.
Thank you. Members, what this was brought forward, there was a case in conservatorship of Daniel Allen. What this does is allow for a mechanism for the court to appoint an attorney ad litem for a potential ward, and actually for that ward to collect, for the attorney fees to be collected up to $1,500. In a lot of situations, if an attorney ad litem is appointed to a ward, they don't have the ability to collect those fees and end up doing the work pro bono. So, but we cap the fees at $1,500. We put a consumer pricing index adjustment on there. And we've worked with several, if not all, interested parties. So I think I can fairly say that this was by agreement, with a lot of hard work with judges and different folks across the state. So with that, I move passage.
Thank you, Chairman. We got a motion and second amendment. We didn't vote on it. All those in favor for the amendment on the bill, say aye.
Aye.
Those opposed, ayes have it. Okay, and got
And that amendment made the bill. Members that rewrote it made it. So I'll just renew my motion.
Shirley Littleton, you recognized.
Thank you, Mr. Chairman. Chairman, I call for previous question.
Question's been called. Any objections? Seeing none, we're voting on House Bill 2003 to go to calendar and rules. All those in favor say aye.
Aye.
Those opposed, ayes have it. Whoops, there goes my phone. That is, turn my feet. Turn my feet.
I got you.
Got you. Chairman, would you like to have the gavel back? Okay. Well, seeing as though you have one more bill next week, this will not be my last time on the gavel, but without objection, we're adjourned.
Good job.
All right.